A very good morning, everyone. I hope you all had a restful night after an incredible day one. Welcome back to day two of the Lay Grand Summit 2025, presented by Lay Confluence, a platform that curates high impact legal, policy, and industry summits across India. We thank you all for being part of this grand gathering of the legal minds. We would like to begin by acknowledging our proud event partners EY, Case Docker, BKG Law Associates, Lamentage Legal, Dispute Resolution Hub, Gyan Nauka, and Lawyer Insta. Your support has made this vision possible. We have a powerful lineup of sessions today with some of the brightest minds in law, business, and policy sharing the stage, so let us begin. To set the tone for the day, let's begin with a few words from Dr. Moksha Kalyanram on From Briefs to Blockchain, Reimagining Legal Systems for the Digital Economy. Let me invite Dr. Moksha Kalyanram on the stage.
Well, the phrase is complicated enough. When you say briefs to blockchain, it has by and large consumed the physical and the digital world together. Now, let me try to put it like this. Let's first start with something called a reality check, which we have vis-a-vis the old world and today's digital world. Now, when I see a dispute today, I'll just narrate an event. There is an investor. Now, this investor wanted to put money which is transferable, which does not have much of tax implication, and the investor wants an agreement to be placed for this particular activity. And they also wanted to have the assets and IPs which are in this particular investments to be tracked, to be identified, and to have the scalability in place. Now, the suggestion which has come was, why don't we adopt a blockchain technology? Well, that's fantastic. Once we adopt it, there are a couple of questions which the members of the legal fraternity should answer. One, what are those clauses which are of crucial importance to form part of your agreement? Now, since I look at when there is a disagreement between the parties, the first place where it is always questioned is, where is the jurisdiction lying for this disagreement? So I generally don't go by the recitals, the parties to the contract, but I always try to see where is my first clause. I start from the last page of the agreement, wherein the dispute resolution clause, the governing laws, the jurisdictions, the serviceability lie. This is the most unseen part of the agreement, and this is the first preferred part of mine. So I always try to evaluate where are the blockchain's basic origin generated, where are the NFT tokens generated, where are they tradable. We address those particular places, identify which jurisdiction is more beneficial from governing law point of view. You cannot have a complex governing law for a jurisdiction selected, because in your agreement, you have a luxury of selecting the jurisdiction. So when you have the luxury of selecting the jurisdiction, you are supposed to see that that jurisdiction exclusively focuses on less governing policies, ease of transferability, ease of implementation of that particular award that comes out. Now, having said that, in legal fraternity, we are supposed to have a basic understanding. I don't say advanced understanding. We are not here to code. We are not here to understand how an NFT is generated. But yes, we are liable to understand what are the tradable norms of NFT, where the tokenization happens, if there is a valuation report given to us, how to read the disclaimers in the valuation report. Because disclaimers and areas of interest give a wider role to understand the valuation, and what is that tokenization scalability is also understandable from there. So from that point of view, agreement, I see that is the place where we start. Then How do you identify that there is an infringement? Because when we are talking about NFTs, we also talk about what are the IPRs involved with it. So how do you identify infringement has to be clearly defined in your agreement. If that is not there, then there will be issues in the agreement. When agreements are debatable, dispute gets widened. The third area which we have to concentrate is how people and parties are connected to the agreement. It generally happens when we say so-and-so company and its group companies. Now, when you write and its group companies, if you are excluding something, you have to mention it over there. If there is a spin-off, that has to be identified as an addendum to the previous agreement. Now, these factors we have to keep in consideration when we are shifting the agreement to a digital world. There was a question posed to me. What is suggested? Having a physical agreements in place, having a digital agreements in place, both in place, what is the best course of action? It is not which in place, you should know where is the agreement as such. Because when the dispute comes, we'll be sharing folders, we'll be searching folders for the actual agreement to be in place. And once that particular agreement is identified, we have locations given to it, it becomes easy for us to monitor and execute. Let me share another scenario. Today we have many tools which talks about smart contracts. Now what's a smart contract? Contract which is not seen on smartphone. A smart contract is that which can be divided, studied, summarized, explained. If the contract which is in front of you is not explainable to the stakeholders, then that contract will not qualify as a smart contract. Contracts are written today exhaustively, but they are also written in such a way that a respective stakeholder, let's say we are talking about a finance department or heads of finance to understand that part of the contract, we can give a particular area and say, these are the areas which summarize your financial constraints and financial evaluations. So if we are grouping the contract under various heads, and these are identifiable by the AI tools, it becomes easy for the contract to be called as a smart contract. Now, there was a common thing which I also see. Today, if we want to summarize, we have many AI tools. What's the challenge we face over there is that summarization is subject to AI's understanding, not our understanding. So we have to specifically ask that set of prompt engineering, which will make us to dig that particular agreement to those summary points which are applicable to you as a stakeholder, or which as a council you explain to the stakeholders whom you are communicating to. That's where a smart contract comes into play. Now in the smart contract, there's one more point which we have to understand is we have digital evidence is always identified by something called logs. Now let's put it in I'll share my experience here so that it will add some value. When we have a case, there was a case which I've been presenting, the entire evidence was on the Google mails, the conversations that have run across a long mail chains and multiple mails. Now it so happened that one of the parties have deleted that particular mail and he said, this was never received by me. I have never seen these particular mails. I am unaware of the notices and communications sent. Now what's the recourse? Your digital evidence has to go back to digital forensic, get a court order, write it to Google, get the log information, produce the log in the court. Once you produce this log, it is an overwhelming evidence. Now this is given by Google only when you have a court order. Though we write a legal notice, they will send one more reply which says, this is confidential information, we can't share, blah, 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 all statutory things they will write. If you have a court order, you have to convince the court that this is the allegation, this is my prima facie case, This is the reason why the order has to be given to me, because I suffer an irreparable loss. Courts tend to give orders. Based on the order, you can get it. The timeline which Google gives you is 21 days. The moment you upload this particular court order, they give 21 days to give the entire information to you. That's a foolproof evidence. It's not just the Google Mail. You have a Google Mail extract with you, give the PDF to the court. That is not a conclusive evidence. That stands as substantive evidence. Now, the last thing which I wanted to put it across is, today we are data-led advocacy. Now, why do we say this is? The information which we have is overwhelming today. And generally, when you go to a commercial contracts and a commercial dispute, they give 3 sets of documents which are really exhaustive. What is the proof that the transaction has happened? They give you bank statements which are voluminous in nature. Second, how do I identify that the company will sustain or this transaction is reflected in the company? If it is running across 5 years, they'll give you 5-year annual reports, which is a real challenge to read. So we have to understand how do we summarize these documents, more so where to see in the documents. Because entire annual report is never an evidence. There is some extract of the annual report which is an evidence which sells your case. But you have to file the entire annual report. But you have to communicate to the judge that except this, nothing is required in the annual report to be browsed upon. People give judgments based on that. And it's not what the judge has gone through. It is where your case is. It's your responsibility to communicate to get a judgment which actually it deserves. That's what I wanted to say. Thank you for listening.